Texas, doing a presentation for the State Bar of Texas on Fair Labor Standards Act. And I just did a survey of all the different rulings from the Supreme Court down to the Appellate Court, the Fifth Circuit Court of Appeals, and several select district court rulings. So top to bottom. And one thing that I learned from reading all those cases so that I could provide an update to the attorneys is that lawsuits are not the same. With overtime lawsuits, they're not the same. You don't file these lawsuits and expect it to proceed in a straight path because some of the significant cases and rulings all were addressing how the employers were able to disrupt the lawsuit with one, an early motion for dismissal. Just reading the lawsuit itself, how it's pled and written, they just found flaws, problems with it, and they just complained to the judge. And in some instances, the judge will give them a partial win, or in other instances, the judge just threw out the lawsuit, and sometimes the judge would reject it. So drafting the lawsuit itself is really important because there are instances where lawsuits are being thrown out just because of the way that they were framed in the first place. Okay, so the second thing is that you don't know how these lawsuits are going to turn out because arbitration may apply. So in these instances that there's arbitration clauses, you just don't know until you file the lawsuit. And once you file the lawsuit, then the company will reveal the arbitration clause and show it to you. And in many instances, they're written badly. And whether or not it's enforceable sometimes goes up on appeal. And as a result, there's a lot of unpredictability that comes with it. And this is just something that comes with the territory. So for someone to just look at it and say on its face, looks like a good lawsuit, we just got to get it on file, it'll proceed in a linear fashion to trial, like it doesn't. There are many ways where the employers were able to disrupt the case by just filing an early motion to dismiss or strategically moving for arbitration. Sometimes, at least in one instance, they moved for arbitration too late and the judge said you waived it. But in many instances, the arbitration refers to a master service agreement, something that the employee doesn't have access to until they file the lawsuit, and a motion to compel arbitration is then filed and it's then attached to that motion as an exhibit. So sometimes you just have to test it, file the lawsuit, and find out if an arbitration clause applies, and then challenge it. Okay, back to work.